ilovedreamingpeach.com.
Hey, sweet peaches. How are you? Oh, I have to do some stretching and walking and dancing. I just realized it's been months. I was like, oh, I'm going to do stretching every day. Did it for like 3 days and then I forgot. And then months went by. I really want to get back into some kind of physical, taking care of myself routine. But anyway, let's see. It's 11:26 p.m. It's Thursday, April 3rd, 2025. For 34 more minutes until it's tomorrow. I'm going to move this thing like that. Maybe take a sip of water. See if I can turn my light down a little. I feel like it's so bright. Well, probably because it's almost midnight. Anyway, the reason I'm popping in is to say, hey, I listened and screen recorded a document, let's see, regarding Justin Baldoni, the Blake Lively. This document was by Bryan Freedman, Justin's lawyer, and Mitchell Schuster, Kevin Fritz. It's a 35-page document. So, as I'm always busy doing many things, I just don't have time to sit and read with my eyeballs anymore. So, I like to listen to things while I'm doing other things. So this is not sponsored, but naturalreaders.com is a good like AI text-to-speech reader. And I paid for, I wonder if I'm going to have to pay for it soon. I think it's been about a year since I've had it. But so, I paid the premium so that I could get the higher quality voices. They sound more realistic and not so fake. So anyway, I copy and pasted it into there and I listened to it. And while I was listening to it, I was screen recording it. And except for one moment when my son walked over here to say something to me and he accidentally kicked my, so I have the long cord. I have my long cord for my charger. So I had it plugged in as it was screen recording, and then he came over to talk to me and he like accidentally kicked the phone, which threw the phone down on the floor, and then the screen like goes sideways. So you can't hear any of that because I'm just screen recording the AI voice reading it and the words going by. But the screen goes like wonky. So anyway, it's like about an hour. I think it's like 63 minutes that the AI voice took to read all through it. And I only partially listened. So I thought, you know what? Instead of me sitting here trying to record myself reading it, which takes fucking damn near forever, if you want to hear a person reading it, I suggest going to the Court of Random Opinion on YouTube. She reads it, or Tilted Lawyer. I think so. I don't know if he's reading it or not. But I'm gonna just share. I'm just gonna share what I screen recorded because maybe other people might want to hear it too, and not mind so much that it's AI recorded. Since I took the time to listen, my son is playing his guitar back there. Since I'm just getting distracted because he's always playing either the electric guitar, the electric bass, or the acoustic guitar, and I just love the fact that he's always doing that, or he's making some music on like some website. So if you're interested, let me read a little bit about what exactly the document is. So today, like I said, for 27 more minutes, is Thursday, April 3rd, 2025. This is case 124 CV 100 and 10049-LJL, document 162, filed today, April 3rd, 2025. This is page 1 of 145. Page 1 of 45. Civil action number, I already said it, it's Blake Lively as an individual plaintiff versus Wayfarer Studios, Justin Baldoni, Jamie Heath, Steve Sarowitz, It Ends With Us Movie, LLC, Melissa Nathan, the agency group, PR, LLC, and Jennifer A. Bell, and Wayfarer Studios, Justin Baldoni, Jamie Heath, It Ends With Us Movie, Melissa Nathan, Jennifer Abel, and Steve Sarowitz against Blake Lively, Ryan Reynolds, Leslie Sloan, Vision PR, Inc., a New York corporation, and the New York Times Company, a New York corporation. So these are the consolidated for pretrial purposes 124 CV 149 and 125 CV 00449 and 125 CV 00779, and those all have dash LJL. So Blake Lively is the plaintiff with Wayfarer as defendants, and then Wayfarer is the plaintiff with Blake Lively and Ryan Reynolds as defendants. Okay, and the groups. So this is document 162, and there's like a long ass table of contents, which I did not put at all on the AI reader. It is many, many, many pages of just like numbers and shit. Okay. Consolidated plaintiffs. Okay, I'm not saying that all again. A memorandum of points and authorities. But wait, what was the thing? It's like consolidated plaintiffs. I don't want to repeat that. Oh, here. Consolidated plaintiffs memorandum of law in opposition to consolidated defendant Blake Lively's motion to dismiss the amended complaint for attorney's fees and costs and to strike Exhibit A. Okay, so this is Justin Baldoni's response in opposition to the consolidated defendant Blake Lively's motion to dismiss the amended complaint, also seeking attorney's fees and costs, and to strike Exhibit A, which is all his evidence. So I'm going to let the AI reader read it. You can listen while you're doing something else. And don't forget to hit like, hit share, hit subscribe, hit the bell. Join me for free here on YouTube, catlovedreamingpeach.com. You can join me on my Patreon for free, catlovedreamingpeach.com. No, just catlovedreamingpeach. You can join me on my website, catlovedreamingpeach.com, where you can be a member, or you can just check out my other videos I've done. Oh, I was obsessed with Karen Reed Trial 1. And okay, I have like a 1 minute left before this 10-minute clip on TikTok is done. I am getting into Karen Reed. The trial is continuing as far as jury selection. I listened to Peter Tragos, lawyer you know today. He said that they have 8 jurors now, but he did a long, interesting video about jury selection and how jurors can get picked and then they can get yeeted. And so even though the number's 8 right now, that can change, especially because this is like a long ass thing. And they also have like the lawyers can get rid of people, and you know, so there's probably another 2 weeks before they actually get the full 12 plus. I'm not sure how many alternates they're going to do. I don't know if they're getting 2 or 4 because it's like a month and a half. It's supposed to be a 6-week trial. So they need to have enough alternates because things happen, things pop up. So if you can't make it, even one day during trial. That's it, you're out. So anyway, I just think it's crazy that I was like so certain, even though I was one of the very, very, very few, I think, who thought she hit him. And I wasn't convinced that she did it like intentionally. I mean, I think that maybe like in that moment, like in the heat of the moment, I'm gonna come roll over you, motherfucker. She was, oof. She was vicious. She was so unlikable. Those voicemails and the way she was like going behind his back trying to get a thang with Brian Higgins, and I just couldn't stand her. And I really just felt like she's super unlikable. But at the same time, but then it was like I also didn't care for the defense, and I felt like their version of what happened is so out there, so outlandish, it's so unbelievable. But then it turned out like there was so much corruption and terrible botched investigation. And Trooper Proctor was like horrible, despicable, and he even got fucking fired because of misconduct specifically about this case. And it's kind of like with Casey Anthony, where Casey Anthony is way worse, I think. But, she did it, but they just didn't have enough evidence to prove it, I guess. I don't know. I didn't watch the whole trial. I just remember being utterly shocked that she got a not guilty verdict, and she's still walking around today. Like Wendy Adelson. Wendy Adelson, I believe, is a cold-blooded killer. Even though she had somebody paid to do it, still cold-blooded. And when her mother finally, Donna Adelson, I don't know when her case is supposed to start, May or something, I'm not sure, to be honest. The kids are goddamn almost adults at this point. I don't know. There's no statute of limitations on murder, but how do you let somebody get away with murder for over 11 years and still not arrest her? And I don't know. I genuinely don't think that. I said if January comes and goes and they haven't arrested her, January 2025, I'm giving up hope. And it came, it went, and it's almost fucking, it's April now. That bitch is not getting arrested at this point. I would be shocked if she did. Like, really. I don't know why they never arrested her. I don't know why certain people, well, I do know why certain people can get away with murder. I do know why. Is that why she's getting away with it? I don't know. Are they going to just take her mom and her brother and be like, we're good with... We got Sigfredo, we got Luis, we got Katie McBenoit, we got Charlie. To me, letting the one who fucking started it all, the one who benefited the most... Oh, wait. Well, now I got distracted because my son called me, but... Anyway, I think I was just bitching about the fact that Wendy Adelson is not arrested, and I think she's the worst of all of them. She's a stone cold killer. And so back to Karen. I don't know. It's funny because I got to the point up until a video that. Who was it? Who played it? Was it Peter? It was Peter Tragos. Peter basically got me convinced that she's, not that she's innocent, but like that there was so many problems and that Judge Cannoni is biased. But then I saw her, on the first day of jury selection. I was like, she doesn't sound biased at all. And I always had doubts about her being biased, but then of course, there's a lot of things that does seem biased, but then again, at the same time, I will say, a lot of the people who think she's biased, also, they don't call her Judge Cannoni. They say, Auntie Bev. And I find that to be highly disrespectful. And I get the fact that, well, is it the fact that you think that she's, you think she's corrupt, so you're being disrespectful on purpose? Or is it misogyny? Are you being misogynistic and you don't think that she could be unbiased, and you are in fact the one who's biased because you just want Karen to be innocent so fucking bad, and you hate the fact that this judge is doing her job. But I do think that, Peter has convinced me that the way she's ruled on several things is definitely different for the defense than the prosecution or, the Commonwealth. So, I don't know. But then the video he was playing of some, what did he say the guy's name? I don't know, some sports guys and some hockey people. And the guy was reminding me of all the things that made me think she is guilty. Like, she hit him. She was drunk. So my thoughts are, I don't think she intended to kill him. But I do think that she hit him with her car, with her SUV, and that she had to have known it. And she might have done it in anger in the moment because she was drunk, I think. We saw her, what looked like putting shots in her cup multiple times. But, like, what was it? I don't know, but... and... a lot of people hate Jen McCabe and the Alberts and stuff, and they were insulting Jen's looks. It's like, you think someone is unattractive. I don't know. It's just so weird. It's like all the things that the people who are very pro Karen have said and thought. I don't know. I'm like, that's not a reason for somebody, like making fun of somebody's teeth. No, there was the how's long to die in the cold, and there was the butt dials, and the thrown away cell phones, and Brian Higgins got rid of his cell phone by going to like an FBI thing, and like, I don't know exactly what they did. A lot of weird stuff. I kind of think that maybe they all despised Karen so much, and they were talking a lot of shit about her. And then like somebody was saying, well, when Jen was on the phone with 911, she didn't sound all distraught, and she said something about there's a man in the snow, and but at the same time she's like, I love John, he was my friend. But I'm like, did she, like, well, she knew, she could have been in shock. It's like people are like, somebody said, oh, Karen was the only one who was hysterical and trying to do anything to save him. And I'm like, well, maybe the Kerry and Jen were in utter shock, and maybe it was like obvious as fuck that John was absolutely dead. Like, he had been literally in the snow all fucking night with a busted head. He was probably like beyond any kind of hope, and they might have just been so shocked and so stunned, and I don't know. Anyway, I'm gonna watch the trial, and I am open to being completely convinced that there's like absolutely no chance that she could have done this, or being convinced beyond a reasonable doubt that she absolutely did. I genuinely don't know. I genuinely think there could easily be another hung jury, or a mistrial, or which is a mistrial, and a mistrial is a hung jury. No, a hung jury is a mistrial, and or they might find her guilty, or they might find her not guilty. I don't know. So that's why I'm intrigued. And so after this ends, it will play the audio of the memorandum of law in opposition to the consolidated defendant Blake Lively's motion to dismiss the amended complaint for attorney's fees and costs and to strike Exhibit A. See ya. Hey, Sweet Peaches, I'm back. It is Friday, April 4th, 2025 at 3:50 p.m. And I was editing this, and then I remembered what I had forgotten to say when my son had cut me off by saying, "Hey, Mom," while I was talking about Wendy Adelson, and just wondering if the fact that they've already arrested. All right, I'm going to read over my phone onto my computer right here. I know this stuff by heart, but it's easier to just read it than trying to remember it. Okay, so Sigfredo Garcia was convicted of first-degree murder and conspiracy to commit murder, sentenced to life in prison. He was the actual shooter. Luis Rivera pled guilty to second-degree murder and received a 19-year prison sentence. He was just a friend of Sigfredo, like long-time childhood friends. And Sigfredo was like, "We got to go do this thing." And Luis had even said, why don't we just rob the lady? And why bother? Like, he was like, "I don't want to kill somebody over some kids. Let's just steal her money." And he said, "No, we got to." Luis said that Sigfredo replied, "No, we got to kill the guy because the lady wants her kids back." Then Catherine Magbanowa initially faced a mistrial. Magbanowa was later found guilty of first-degree murder, conspiracy to commit murder, and solicitation of murder. She was sentenced to life in prison plus 2 consecutive 30-year terms, which is fucking insane because she did not roll over on Charlie nor Wendy. She didn't fucking speak up against Sigfredo Garcia, who was her baby daddy, on and off husband. And she was Charlie Adelson's on and off girlfriend. And she got roped in. But, if your man's like, "Hey, I want to kill my sister's ex-husband," and you're like, "Okay, cool, I can get my baby daddy to do it," you should probably be in prison. Okay, then Charlie Adelson, Markel's former brother-in-law. Adelson was convicted of first-degree murder, conspiracy to commit murder, and solicitation of murder. He received a life sentence plus 2 additional 30-year terms. Ooh. And that was in 2023, I believe. Charlie was arrested April 21st of 2022. Dan was murdered in 2013. Was it 2013 or 2014? And so it was 8 years later that Charlie was arrested. Dan Markel was murdered on July 18th, 2014. He actually died after midnight the next day. Then the motherfucking grandma from hell, Donna Adelson, Markel's former mother-in-law, was arrested in November of 2023 at the Miami International Airport while attempting to book a motherfucking out of here, attempting to board a flight into Vietnam, a country without extradition treaty to the U.S., which is what she specifically was looking for. She faces charges of first-degree murder, conspiracy to commit murder, and solicitation of murder. Her trial is set to begin, scheduled on June 9th of 2025. As of now, Wendy with an I because she lies, Markel's ex-wife, and her father, Harvey Adelson, have been named by prosecutors as conspirators in the killing. However, they have not been charged, which is a fucking shame and a shock. And so that's what I was saying, like, does the Tallahassee Police Department just feel like, well, we got enough, we got enough people, even though the fucking top of the pyramid, in my opinion, allegedly, the one who started it all, the fucking piece of shit to start that snowball rolling, the one who wanted to fucking get him killed so she could take her kids back down to Miami where she wanted to be. She was fighting him like a fucking mad woman, trying to get her children away from him to go down to where she wanted to be. She hated Tallahassee. She wrote a book about it. And if any old mommy sleuth internet person like me can find all this evidence that makes it so obvious that she is guilty, I'm disgusted and disappointed that she's still walking free. She supposedly moved to Texas. The house next door is getting construction, so you maybe can hear all that shit. Wendy Adelson recently participated in a deposition related to her mother, Donald Adelson's upcoming murder trial. The deposition took place on March 21st, 2025, with Wendy attending remotely from Austin, Texas. Regarding her relocation, while there have been reports and discussions suggesting that Wendy intended to move to Austin, Texas, concrete evidence confirming her permanent residence there is limited. Notably, her Miami Beach condominium was listed for rent with an availability date of August 1st of 2024, which may indicate a move. However, definitive confirmation of her current residence remains elusive. It's important to note that that bitch has not been charged in connection with the 2014 murder of her ex-husband, Dan Markel. She's listed as a witness on her mother, Donald Adelson's trial, which is scheduled to begin June 3rd, April, March. So major. So like 2 months from now. So anyway, I just wanted to add all that back to say that I was obsessed with that case, with Charlie's case, with following whether or not, I could find evidence that made it seem like Wendy was a part of this. I think she was the whole reason for it to happen. And I have a huge playlist on this channel about it. If you're interested in going back to it, I have noticed that some of those videos still get a lot of views, which is great, because even though I made all those videos like a year or so ago, Donna's trial is happening. It's up and coming in a couple of months. There have been various hearings throughout this time, and so I have, I think, for jumping now to Karen Reed, I believe that I had a video for every single day of trial. Let me see. All right, I'm not sure if there's one for every single day, but there's 54 videos in my Karen Reed trial Justice for John O'Keefe playlist. I've got 50 videos in my Justice for Dan Markel Guilty AF Adelson's playlist. And I've got 64 videos in my Justice for Justin Baldoni or Blake playlist. And I have other video playlists as well. I have a small one, 8 videos for Stephen Twitch Boss and his shady AF fucking widow, Allison Holker. I went from being massive, I love these people, I'm huge fans, to something shady about that bitch. I have, let's see what other playlists. I have I've got a 61 video playlist when I was following the election, and various things about Trump in there. I fucking hate that scumbag Hitler. He's a shitler, actually. And what else? I've got a 6 video playlist about no contact with my biological mother. A short one about JonBenet Ramsey. I have a video playlist about the power of reasons and what real pro-life is actually about, pregnant pauses. I have a 10 video playlist called I Would Have an Abortion, about my views on abortion and all the times in my life when, if I had gotten pregnant, I would have had an abortion. Although I have not ever had an abortion, I had fertility issues all my life, and now I have 2 miracle babies that were conceived naturally because I healed myself. So I have an SP Obsession Heal It with Self-Love and Love for Others playlist. So please join me. I have a lot of free content as well as some members only content on my Patreon as well as my YouTube. So check it all out, and I will see you there. And I just wanted to add these thoughts about Wendy with an I, because she lies and she's a fucking horrible, evil person. Way, way, way more evil than Karen Reed, in my opinion. I think Karen Reed is a bad person who has a lot of problems, and she's got whatever issues, but she was very wealthy. I don't know if she's still very wealthy, but so I want to watch her trial, which is happening now. So See you later. Don't forget to hit like.
Case 1:24 CV 10049. LJL document 162 file 040325 page 10 of 45 consolidated plaintiffs Wayfarer Studios LLC Wayfarer Justin Baldoni Jamie Heath. It ends with us Movie LLC IWU Melissa Nathan Jennifer Abel and Steve Sarowitz collectively. The Wayfarer parties respectfully submit this memorandum of law in opposition to consolidated defendant Blake Lively motion to dismiss the amended complaint for failure to state a claim for attorney's fees, costs, damages, and punitive damages, and to strike Exhibit A of the amended complaint pursuant to Federal Rule of Civil Procedure 12B, 6, and F, and California Civil Code Section 47.1, the motion. Memorandum of Points and Authorities I. Introduction. The first amended complaint, FAC, contains hundreds of pages rife with factual detail about Lively's calculated efforts first to extort and manipulate the Wayfarer parties into ceding total control over the film It Ends With Us, the film, and then to defame and scapegoat them when her plan backfired. Nonetheless, Lively refuses to accept responsibility for the trail of untold destruction she left in her wake. But she goes further still. Lively asks this court not only to dismiss the FAC, but also to award her attorney's fees, costs, and treble and punitive damages for the Wayfarer party's constitutionally protected act of petitioning the court for redress of their grievances. In essence, Lively asks the court to find that she is immune from any culpability for her wrongful acts. And instead, it is the Wayfarer parties who must be punished for daring to exercise their constitutional right to seek a remedy from the court for her lies. The motion must be denied. The FAC specifically alleges abundant facts in support of the Wayfarer party's claims against Lively, based both on her own direct actions and on those of her co-conspirators and agents. The Wayfarer parties have pleaded allegations against Lively sufficient to defeat dismissal, and Lively's arguments often border on frivolous. In particular, one case 1:24 CV 10049, LJL document 162 filed 040325 page 11 of 45 Lively's argument that California Civil Code Section 47.1 immunizes her from liability would require the court to determine as a matter of law that she acted alone and without malice, and that she had a reasonable basis for her claims. In other words, to make findings of disputed fact not apparent on the face of the pleadings, which flies in the face of the well-established rules governing motions brought under Rule 12b-6. When the court assumes the truth of the facts set forth in the FAC, as it must in ruling on this motion, the only possible result is a denial of the motion in full. Regardless, any technical defects or instances of inartful pleading in the FAC can be readily cured by amendment, which is freely allowed. And the Wayfarer parties are every day obtaining further facts to plead in support of each of their claims against Lively. Furthermore, the Wayfarer parties can amend their complaint to more fully incorporate the allegations of Exhibit A into the body of the complaint, mooting the motion to strike. Finally, even in the extremely unlikely event that the court determines that dismissal without leave to amend is appropriate, Lively is still not entitled to the award of fees, costs, treble damages, and punitive damages that she seeks. The draconian, one-sided sanctions that Lively demands under Cal Civ Code 47.1b are, in a matter of first impression, barred by the Norr-Pennington Doctrine, which precludes the imposition of liability for the exercise of rights protected by the Petition Clause of the First Amendment. The First Amendment protects the right to petition the government for a redress of grievances. In other words, the Constitution safeguards Americans' right to ask the government to take action, such as by bringing legal claims. The Norr-Pennington Doctrine bars courts from punishing litigants for bringing good faith claims, including through the imposition of harsh penalties, like the treble damages award Lively seeks here. Because the Wayfarer parties have brought good faith claims against Lively that are neither objectively baseless nor subjectively brought for improper purposes, the First Amendment protects them from 2 Case 1:24 CV 10049, LJL document 162 filed 040325 page 12 of 45, being punished for the act of seeking relief from this court. In short, the motion must be denied or, at most, granted with leave to amend. In no event, on this motion or at any stage of this proceeding, will the First Amendment permit the extreme and unconstitutional award of fees, costs, and treble and punitive damages Lively demands. 2. Legal standard and factual background pursuant to Federal Rule of Civil Procedure 10C. The Wayfarer parties incorporate by reference their allegations in the FAC DKT. Number 50, and the recitations of legal standards and factual backgrounds in their oppositions to the Rule 12b. 6. Motions of consolidated defendants Leslie Sloan and Vision PR, Inc., together. The Sloan parties, DK no. 121, The New York Times Company, NYT, DKT. Number 127, and Ryan Reynolds, DKT. Number 160. Lively and the Wayfarer parties agree that California law applies to their claims. Moat. At 10 to 11-3. Argument A. The FAC states a claim for defamation against Lively won under California law. Defamation is an invasion of the interest in reputation. The tort involves the intentional publication of a statement of fact that is false, unprivileged, and has a natural tendency to injure or which causes special damage. Smith v. Maldonado. 72 calories app. 4th 637, 645, 1999. Defamation may consist of either libel or slander. Cal Civ Code 44. Libel is defined as a false and unprivileged publication by writing, which exposes any person to hatred, contempt, ridicule, or obloquy, or which causes him to be shunned or avoided, or which has a tendency to injure him in his occupation. Cal Civ Code 45. Slander is a false and unprivileged publication, orally uttered. Cal Civ Code 46. Where the defamation is clear without the need for any explanation. It is considered one Lively incorporates by reference the arguments made by other parties that the FAC contains impermissible group pleading. Moat. At 11:14. In response, the Wayfarer parties incorporate their responsive arguments from their oppositions to the motions to dismiss of the Sloan parties, the NYT, and Reynolds, and reiterate that any defect can easily be cured by amendment. 3 Case 1:24, CV 10049, LJL Document 162 filed 040325 page 13 of 45 defamation per se, and damages are presumed. Contento v. Mitchell, 28 calories app. 3D 356, 358, 1972. An action for damages based on language defamatory per se. Damage to the plaintiff's reputation is conclusively presumed, and he need not introduce any evidence of actual damages in order to obtain or sustain an award of damages. The definition of libel, per se, is very broad and has been held to include almost any language which, upon its face, has a natural tendency to injure a person's reputation, either generally or with respect to his occupation. Bates v. Campbell, 213 calories 438, 441, 1931. A statement will qualify as slander per se if it charges the commission of crime or tends to directly injure a plaintiff with respect to the plaintiff's profession, trade, or business by imputing something that has a natural tendency to lessen profits. Cal Civ Code 46. Where the defamation is not per se and some explanation is needed to show why the statement was defamatory, the plaintiff is required to allege and prove that he or she suffered special damages, such as harm to reputation, shame, or economic damages. Cal Civ Code 45, 48A. 1. The FAC identifies specific and unprivileged defamatory statements. Lively's contention that the Wayfarer parties fail to allege specific defamatory statements made by her fails for 2 reasons. First, Lively is liable as the principal for the statements made by her agents, the Sloan parties, and Reynolds. Second, Lively herself is alleged to have made defamatory statements. A. Lively is liable for statements made by the Sloan parties and Reynolds under the principles of agency and the doctrine of respondeat superior. It is well settled that, under California law, any who takes a responsible part in a publication of defamatory material may be held liable for the publication. Overstock.com, Inc. versus Gradient Analytics, Inc. 151 calories app. 4688, 712, 2007. Abrogation on other grounds recognized in Muddy Waters, LLCV, Superior Court, 62 calories app. 5th 905, 924, 2021, citing Osman v. EWAP, Inc., 153 calories app. 3D 842, 852, 1984, Horan versus Hickson, 209 calories app. April 4th case 1:24, CV 10049, LJL document 162 filed 040325 page 14 of 45, 256, 275 to 76, 2012, same. Shively versus Bozanic, 31 calories 4:12:30, 12:45, 2003, as modified December 22, 2003. Matson versus Dvorak, 40 calories app. 4th 539, 548 to 49, 1995. New York law is in accord. A person authorizing others to speak on their behalf can be held vicariously liable for defamatory statements made by its agents. Gottwald versus Sebert, 148N.Y.S.3D. 37. 46, First Step 2021. Aft as modified, 40N.Y.3D. 240, 2023, citing National Puerto Rican Day Parade, Inc. versus Casa Pubbles, Inc. 79.D.3D. 592, 594 to 95, First Step 2010. See also Buck versus Zwelling, 272A.D.2D. 895, 895, Fourth Dep 2000. Employer may be liable for employees' intentional torts, including defamation. As alleged in the FAC, Lively defamed the Wayfarer parties on her own behalf, and through her agents, the Sloan parties and Reynolds. See Cal Civ, Code 2295. An agent is one who represents another, called the principal in dealings with third person. FAC 814, 15, 17, 187, 190, 192 to 94, 282. Indeed, the actual smear campaign was orchestrated by Sloan at Lively's direction. FAC 194. At all relevant times, the Sloan parties were engaged by Lively to serve as her public relations representatives and manage her dealings with the media. Fac opt 14 minus 15, 184 232 minus 33, 282, 298. Lively and the Sloan parties stood in an agency relationship, with Lively as the principal and the Sloan parties as her agents. At all relevant times, Reynolds, too, was in an agency relationship with Lively, representing her in dealings with WME and others, and acting as her representative in dealings with Wayfarer and Sony. Fac opt 14, 16, 18, 128, 130, 133, 162, 164, 176, 250, 253, 55. The Sloan parties and Reynolds acted as Lively's henchmen in carrying out the vicious scheme to usurp the film franchise and destroy the Wayfarer parties, with the former leveraging media connections and the latter leveraging entertainment industry connections. As alleged, Lively acted with and through them. Under the principles of agency, Lively is liable for defamation by the Sloan parties and Reynolds. In California, a principal is liable to third parties for acts undertaken by her agents in the course of such agency that are wrongful in their nature. See Cal Civ, Code 2343-3, as 5 case 1:24, CV 10049. LJL document 162 filed 040325 page 15 of 45 used in Cal Civ. Code 2343. Acts are wrongful when they constitute an independent tort, such as defamation. Perdia v. HR Mobile Services, Inc., 25 calories app. 5th 680, 693, 2018. The Sloan parties made defamatory statements as agents of Lively, their principal, squarely within the course and scope of their agency. Indeed, communicating with the press on Lively's behalf is exactly what they were hired to do. Thus, the Sloan parties acted with actual authority, or authority that the principal Lively intentionally conferred upon the agent Sloan, or intentionally, or by want of ordinary care. Allow Ed Sloan to believe H. herself to possess. Cal Civ. Code 2316. As the Sloan party's employer, Lively is also liable for their statements under the doctrine of respondeat superior. Point 2, under the doctrine of respondeat superior. An employer may be held liable for a defamatory statement made by its employees. Reese versus Barton Healthcare Systems, 693 F. Sup. 2D 1170, 1191, ED Cal 2010. Quoting Kelly versus General Telephone Co., 136 calories app. 3D 278, 284, 1982. Citing Sanborn versus Chronicle Pub. Co., 18 calories 3D 406, 411, 1976. See also Rivera versus National RR Passenger Corp., 331 F. 3D 1074, 1080, 9th Circle. 2003. Noting that a corporation may be held liable for defamatory statements made by its employees under the doctrine of respondeat superior. Respondeat superior liability is triggered if the defamation occurred within the scope of the employee's employment, even if the principal is not aware of the statement and the statement was not made for the benefit of the principal. Rivera, 331 F. 3D at 1080. Statements are made within the scope of employment if such statements are those that may fairly be regarded as typical of or broadly incidental to the enterprise undertaken by the employer. 2. Given the degree of control Lively is alleged to have exercised over the Sloan parties, they clearly stand in an employment relationship under California law, regardless of how the engagement was styled. C.E.G. S. G. Borello and Sons, Inc. v. Depth of Indus. Rels. 48 calories 3D 341, 349, 1989. The label placed by the parties on their relationship is not dispositive, and subterfuges are not countenanced. The essential characteristic of an employment relationship is the right to control and direct the activities of the person rendering service, or the manner and method in which the work is performed. Villanazzo versus City of Los Angeles. 37 calories 2D 718, 721, 1951. See also Cal Code Regs, Tit. 2, 11008C. Any individual under the direction and control of an employer under any appointment or contract of hire or apprenticeship, express or implied, oral or written. In addition, the determination of employment status is a question of fact. Borello, 48 calories 3D at 349. 6 case 1:24 CV 10049. LJL document 162 file 040325 page 16 of 45 ID. Holding that corporation could be liable for statements made by the plaintiff's supervisors and coworkers about the plaintiff's falsification of a time card and alleged threats made. C. McLaughlin v. Bell, 261 F. 3D 908, 912, 9th Circle. 2021. Holding that employees' defamatory statements made at work about work-related matters were within the scope of their employment for purposes of respondeat superior under California law. Mary M. v. City of Los Angeles, 54 calories 3D 202. 209, 1991. Finding that an action is within the scope of employment, when in the context of the particular enterprise an employee's conduct is not so unusual or startling that it would seem unfair. To include the loss resulting from it among other costs of the employer's business. Citations and internal quotation marks omitted. As alleged in the FAC, the Sloan parties made a series of defamatory statements about the Wayfarer parties within the scope of their employment agency. As to Baldoni, the FAC alleges that the Sloan parties made statements to third parties, including without limitation to the NYT and other news outlets, to the effect that Baldoni is a sexual predator who sexually assaulted Lively, FAC 8, 193, 282, and that Baldoni retaliated against Lively and others for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. FAC 325. The Sloan parties also made other false statements in response to media inquiries concerning Lively's wrongful accumulation of power over the production, the means by which she did so, i.e., false accusations of sexual misconduct, and the resulting turmoil. Fact 189 to 90, although not in an employment relationship, Reynolds, too, was acting as Lively's agent when he defamed the Wayfarer parties. As alleged, on at least 2 occasions, Reynolds stated to executives at WME, Baldoni, and Wayfarer's talent agency that Baldoni is a sexual predator. Fact 8 162. FACXA at 99 to 100. Reynolds knew, as the jury will know, that an accusation of this kind renders the target persona non grata. By referring to Baldoni as a sexual predator, 7 Case 1. 24 CV 10049. LJL document 162 filed 040-325 page 17 of 45. Reynolds attempted to render untenable any continued ties between WME and Baldoni. With the Sloan parties, who made similar defamatory statements to the press, Reynolds was part of the campaign to destroy Baldoni's reputation and career. Fact 8 14 273, 296, 330. As to the other Wayfarer parties, the FAC alleges that Lively and or her agents or co-conspirators made statements to third parties, including the NYT and other news outlets, to the effect that the Wayfarer parties engaged in, permitted, and or failed to prevent sexually inappropriate conduct toward Lively and others, and retaliated against Lively for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. Fact 273, 74, 276, 325. As alleged, Lively and the others told the NYT a false and damning story about an insidious PR sabotage operation deployed as revenge for sexual harassment complaints, with the knowledge and intent that the newspaper would publish the false story. Fact 273, IED. 276, the Sloan parties propounded a false smear campaign, narrative designed to destroy the Wayfarer parties. For the purposes of this motion, the bottom line is that the FAC alleges that Lively orchestrated, participated in, and directed her agents to carry out a defamation campaign designed to ruin the reputations and careers of the Wayfarer parties. Construing the allegations in the FAC as true, there is sufficient evidence that Lively took a responsible part in publishing each of the allegedly defamatory statements by approving or authorizing them prior to publication. Dickinson v. Cosby, 37 calories app. 5th 1138, 1156, 2019. Citing Overstock.com, 151 calories app. 4th at 712. Although the Wayfarer parties submit that Lively personally approved or authorized the defamatory statements made by the Sloan parties and Reynolds, Lively is liable regardless because she ratified them after the fact. In California, ratification is a well-established doctrine for assigning vicarious liability to a principal for torts, even where those torts are outside of the scope of the agency relationship. See Cal Civ Code 2307, Thomas v. Regents of U. of California, 97-8 Case 1:24, CV 10049, LGL document 162 filed 040-325 page 18 of 45 calories app. 5th 587, 618, 2023. The theory of ratification is generally applied where an employer fails to investigate or respond to charges that an employee committed an intentional tort, such as assault or battery. Quoting CR v. Tenet Healthcare Corp., 169 calories app. 4th 1094, 1110, 2009. An employer's failure to investigate or respond to charges that an employee has committed an intentional tort may be evidence of ratification by the employer. Thomas, 97 calories app. 5th at 649, quoting Samantha BV, Aurora Vista Del Mar, LLC, 77 calories app. 5th 85, 109, 2022. See also Thomas, 169 calories app. 4th at 1111, Our ratification may occur when an employer learns of misconduct and fails to discharge an agent or employee. Whether an employer has ratified an agent's conduct is generally a factual question. ID at 1110. Ratification is the voluntary election by a person to adopt in some manner as her own an act which was purportedly done on her behalf by another person, the effect of which is to treat the act as if originally authorized by her. A purported agent's act may be adopted expressly, or it may be adopted by implication based on conduct of the purported principle from which an intention to consent to or adopt the act may be fairly inferred, including conduct which is inconsistent with any reasonable intention on her part, other than that she intended approving and adopting it. Rakestraw versus Rodriguez. 8 calories 3D67. 73 1972. Internal citations and quotation marks omitted. The effect of a ratification is that the authority which is given to the purported agent relates back to the time when he performed the act. ID. See Restatement 3rd of Agency. For .02, 2006, ratification retroactively creates the effects of actual authority. A principal's failure to discharge an agent after learning of her wrongful acts may show ratification. See, e.g., Delfino versus Agilent Technologies, Inc., 145 calories app. For 790, 810, 2006. Here, the Wayfarer parties have alleged that Lively fabricated her claims of sexual misconduct and knew, or had reason to know, that there was no untraceable smear campaign. Assuming the truth of these allegations, as the court must for purposes of a 12b(6) motion, id 9 case 1. 24 CV 10049, LJL document 162 filed 040325 page 19 of 45, follows that Lively knew the statements of the Sloan parties and Reynolds, which stated the opposite, contained falsehoods. Dickinson, 37 calories app. 5th at 1158. Given that the Sloan parties were Lively's public relations representatives and Reynolds her husband, business partner, and designated representative, it is reasonable to infer, and the FAC alleges, that they were speaking on her behalf or with her authorization. Not only did Lively not immediately terminate the agency relationships or retract or clarify their statements, she doubled and tripled down, ratifying them and making them her own. In such circumstances, the effect is as if Lively had approved or authorized the statements at the time the Sloan parties and Reynolds made them. Restatement 3rd of Agency 7.03. A principal is subject to direct liability to a third party harmed by an agent's conduct when the principal ratifies the agent's conduct. Further, in addition to authorizing an agent's otherwise unauthorized act, ratification may result in the creation of an agency relationship where none previously existed. See Rakestraw, 8 calories 3D at 73. Finally, as previously discussed, Lively engaged in confirmatory conduct, which suggests ratification. Such confirmatory conduct is not necessary, however, because a principal may ratify acts through conduct inconsistent with disapproval. Gates versus Bank of America, 120 calories app. 2 des 571 576 1953. B. Lively made defamatory statements herself separate and apart from the actions of her agents. Lively made defamatory statements about the Wayfarer parties in her individual capacity. Specifically, the FAC alleges that Lively told the NYT that the Wayfarer parties engaged in, permitted, and or failed to prevent sexual misconduct and orchestrated a smear campaign in retaliation for Lively's purportedly protected disclosure thereof. Fact 257, 266, 277, 274, Lively also falsely claimed to the NYT that the Wayfarer party's agreement to the 17-point letter was proof positive that sexual harassment was endemic on the film set, FAC 270, and that the Wayfarer parties had responded to 10 case 1. 24 CV 10049, LJL document 162 filed 040325 page 20 of 45, Lively's complaints about purported sexual harassment by plotting to destroy her reputation. FAC 272. In short, Lively told the NYT a false and damning story about an insidious PR sabotage operation deployed as revenge for sexual harassment complaints. With the knowledge and intent that the newspaper would publish that false story. FAC 273. The fabrications made by Lively are further detailed below and exhaustively outlined in the FAC. 2. The Wayfarer party's defamation claim is timely. Lively statute of limitations argument is meritless. Specifically, Lively contends that the defamation claim is time-barred under California and New York law by a 1-year statute of limitations. Mo. At 13 to 14, a review of the FAC makes clear, however, that the earliest statements at issue are those of Reynolds in July 2024. Although Lively implausibly argues that the defamation claim arises from the 17-point list presented to Wayfarer in or around November 2023, that is wrong. Although certain of the Wayfarer party's claims implicate the 17-point list and Lively's conduct during production, the defamation claim arises from statements made between July 2024 and December 2024. The instant action is, therefore, timely. 3. The defamatory statements are not privileged. Lively also argues that the Wayfarer party's defamation claim fails because the statements at issue are protected by 3 overlapping privileges: the litigation privilege, the so-called sexual harassment privilege, and the fair report privilege. Mo. At 15 to 21, but as detailed below, none of the 3 privileges insulate Lively, not only as a legal matter, but as a factual one as well. 33. The cases cited by Lively in support of her request for dismissal with prejudice do not help her. In Newberry v. Fiberglass Structural Ng, Inc., 2007 WL 445450 at 1 WD Wash. February 6, 2007, the plaintiff filed suit for defamation against an expert witness who had consulted about the plaintiff's alleged negligence with an engineering company embroiled in separate pending litigation with the plaintiff. ID at 1. As a threshold matter, the statements in question were made in the context of and in relation to pre-existing litigation, placing such statements squarely in the crosshairs of the litigation privilege. ID at 3. Here, by contrast, Lively statements and those of her agents and co-conspirators were made prior to any litigation between the parties and without any relation thereto. Moreover, while the court dismissed the complaint on a 12b(6) motion, it did so without prejudice and with leave to amend. ID at 7. While the court later granted summary judgment in the defendant's favor, it could not, and did not, definitively resolve the privilege issue based solely on the pleadings. Further factual development was necessary. See Newberry v. Fiberglass Structural Ng, Inc., 2007 WL 247, 7376 at 6 WD Wash. August 28, 2007, Aft. 298F, Apex 615, 11 Case 1:24, CV 10049, LGL Document 162 File 040325 page 21 of 45-4. The litigation privilege does not apply. The litigation privilege, codified in Cal Civ. Code 47B, provides that a publication or broadcast made as part of a judicial proceeding is privileged. T. He privilege applies to any communication, 1. Made in judicial or quasi-judicial proceedings, 2. By litigants or other participants authorized by law, 3. To achieve the objects of the litigation, and 4. That have some connection or logical relation to the action. Silbert v. Anderson, 50 calories 3D 205, 212, 1990, as modified March 12, 1990. The principal purpose of the litigation privilege is to afford litigants and witnesses the utmost freedom of access to the courts without fear of being harassed subsequently by derivative tort actions. ID. At 213, a communication protected by the privilege must be in furtherance of the objects of the litigation. ID. At 219, the communication must be connected with, or have some logical relation to, the action. ID at 219 to 20. Lively's litigation privilege argument is predicated on the false premise that the statements at issue were made in legal pleadings or as part of a legal proceeding. Mo. At 16 to 17, but that is simply not the case. The Wayfarer party's defamation claim against Lively arises from her statements and those of her agents to the media, WME executives, and others from July-December 2024. The FAC does not seek to hold Lively liable for even otherwise defamatory statements actually made in the CRD complaint or lawsuit. For the litigation privilege to apply, the logical relation between the Communicative Act 2008 WL 481, 7106, 9th Circle, 2008. Also distinguishable is Hagendorf v. Brown, 699 F.2D 478, 9th Circle, 1983. Amended 707 F.2D 1018, 9th Circle, 1983. Hagendorf involved a defamation lawsuit based on a demand letter sent by the defendant's attorney to the plaintiff and his publisher, asserting that the plaintiff's article infringed on the defendant's copyright and seeking a retraction, an acknowledgement of authorship, and compensation. ID at 479. A demand letter made in anticipation of a copyright infringement suit in an effort to settle the claim is clearly related to an action and made to achieve the object of such action. ID at 480. That distinguishes the demand letter from the statements of Lively and her agents to the press and other third parties, which were not made in furtherance of legitimate litigation goals. These facts and circumstances also materially distinguish this case from Mahan v. Rock Nation, LLC, 2015 WL178, 2095, at 2, SDNY April 15, 2015, AFT 634F, Apex 329, 2 DCIR, 2016, in which the plaintiff asserted various tort claims arising from statements made by the defendants to the LAPD, resulting in what the plaintiff claimed was a sham proceeding. ID at 2. Because the statements were made to the police, the Mahan court could readily apply the litigation privilege based on the pleadings. Here, the statements were made to the press and various third parties, not law enforcement and not in relation to any judicial proceeding. 12 Case 1:24, CV 10049, LGL Document 162 Filed 040325 page 22 of 45, and the litigation must be a functional connection. Rothman v. Jackson, 49 Calories App. 4th 1134, 1146, 1996. This has been interpreted by California courts to mean that the communication must function as a necessary or useful step in the litigation process and must serve its purposes. ID. Thus, while such acts as filing a lawsuit or, in many cases, sending a demand letter are protected, communicating with the public or the press is not, even where it advances the litigation by rallying the masses. Indeed, the litigation privilege does not protect litigating in the press. See Rothman, 49 Calories App. 4th at 1149, Get Fugu, Ing versus Pattenbogs LLP, 220 Calories App. 4th 141, 153 to 54, 2013. Dickinson, 17 Calories App. 5th at 281 and .11. Such an extension would not serve the purposes of the privilege. Indeed, it would serve no purpose but to provide immunity to those who would inflict upon our system of justice the damage which litigating in the press generally causes. Poisoning of jury pools and bringing disrepute upon both the judiciary and the bar. Rothman, 49 Calories App. 4th at 1149. In Paglia and Associates Construction, Inc. versus Hamilton, 98 Calories App. 5th 318, 325, 2023. For example, the court observed that the defendant's online posts, while related to an ongoing proceeding, were mere unprotected public denunciations of the plaintiff. Furthermore, even though certain pre-litigation activity is protected by the litigation privilege, albeit not Lively's, such protections only apply when litigation is seriously considered. Action Apartment Association, Inc. versus City of Santa Monica, 41 Calories, 4th 1232, 1251, 2007. While Lively is likely to point to her now pending lawsuit in response, the Wayfarer parties allege and maintain that Lively never intended to file a civil lawsuit, which would have triggered the Wayfarer parties' right to discovery. FAC 4. Lively did not ask the CRD to investigate Wayfarer. she requested a right to sue and then did not sue for weeks. ID. As alleged in the FAC, Lively's pre-litigation communications, therefore, did not relate to litigation that was being contemplated in good faith. Action Apartment Association, 41 Calories 4th at 1251. And although Lively may contest the Wayfarer party's assertion, W. Heather a pre-litigation communication 13 Case 1. 24 CV 10049. LGL document 162 filed 040325 page 23 of 45 relates to litigation that is contemplated in good faith and under serious consideration is an issue of fact. ID. Thus, Lively's litigation privilege argument cannot be considered on this motion. 5. The sexual harassment privilege does not apply Section 47.1 of the California Civil Code, or what Lively calls the sexual harassment privilege, protects a communication made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination. Cal Civ. Code 47.1a, point 4a. Lively's defamatory statements were made with malice and without a reasonable basis, in fact, as stated above. Civil Code Section 47.1 applies only to communications made without malice. Cal Civ. Code 47.1a, subsection C, further provides that his section shall only apply to an individual that has, or at any time had, a reasonable basis to file a complaint of sexual assault, harassment, or discrimination. Cal Civ. Code 47.1c. Those requirements that the communications be made without malice and with a reasonable basis in fact are why Lively's arguments fall flat. As alleged in the FAC, Lively fabricated her allegations of sexual harassment, either wholesale or by exaggerating benign and not harassing interactions in a concerted, malicious effort to seize control of the film and later to restore her reputation after a well-publicized series of marketing missteps that sullied her reputation. Specifically, Lively was hired to play the lead role of Lily Bloom. FAC 27. As part of the subsequent negotiations, Lively was granted an executive producer credit, a ceremonial title often given to talent of Lively stature. ID 27. However, Wayfarer and Sony refused to agree to Section 47.1. which took effect on January 1st, 2024, has not been addressed in a single published or unpublished judicial decision. Thus, the court's treatment of the statute will be a matter of first impression. Section 47.1's mandatory award of treble and punitive damages is, in fact, almost certainly unconstitutional under the Noor-Pennington Doctrine, as violative of the First Amendment's guarantee of the right of the people to petition the government for a redress of grievances. U.S. Const. Amend. I. Sosa v. DirecTV. Inc. 437F. 3D 923. 929. 9th Circle. 2006. Under the Noor-Pennington Doctrine, those who petition any department of the government for redress are generally immune from statutory liability for their petitioning conduct. Sosa. 437F. 3D at 929. Citing Empress LLC v. City and County of SF, 419F. 3D 1052, 1056, 9th Circle. 2005. 2006. Under the Noor-Pennington Doctrine, those who petition any department of the government for redress are generally immune from statutory liability for their petitioning conduct. Sosa. 437F. 3D at 929. Citing Empress LLC v. City and County of SF, 419F. 3D 1052, 1056, 9th Circle. 2005. By imposing a statutory penalty on plaintiffs for unsuccessfully bringing certain types of lawsuits, even when they do so in good faith. Section 47.1 appears to flatly violate the Noor-Pennington Immunity Doctrine. See infra Section 3.g. 14 Case 1. 24 CV 10049. LGL document 162 filed 040325 page 24 of 45 give Lively a true producer credit because such a title would not accurately reflect the role she was asked to play. ID. Wayfarer did not request or require that Lively contribute to the film in any capacity beyond her roles as actor and executive producer. ID. Although at the beginning of the production, it appeared that Lively and Baldoni would have a positive, collaborative creative partnership, FAC 28, Lively had other intentions. In an interview with Forbes in 2022, 3 months before she was cast as Lily, Lively admitted, although not to Wayfarer or Sony, that she needs to have authorship in order to feel fulfilled, which producers and directors often perceive as a rug pull because they hired her to be an actress. 5, as alleged in the FAC. That is exactly what happened on the set of It Ends With Us. Almost immediately, Lively began inserting herself into the production process in intrusive ways well beyond the scope of her contractual entitlements. FAC 31. Lively's intrusion started with the wardrobe, then extended to rewriting the script, which happened daily and significantly disrupted the carefully planned production schedule and placed significant stress on the production crew and financial strain on Wayfarer. FAC 43. Although Lively's pattern of domineering interference caused unending interruptions to the production process, leading to entirely unnecessary stress, chaos, and delays, FAC 62. Lively and Baldoni had a somewhat warm relationship during this early period of production. Fact 55 to 62, however, production was halted through the summer of 2023 due to the WGA and SAG-AFTRA strikes. The dynamic began to change during the strikes when Lively began inserting herself into 5, just a few months prior to her casting as Lily. Lively outlined her modus operandi during the 2022 Forbes Power Women's Summit. When I was younger in my career, I would sort of shape myself to the version of myself I thought that they wanted. Or when I showed up on a set, I knew that they just wanted me to show up and look cute and stand on a little pink sticker where I'm supposed to go and say what I'm supposed to say. But I also knew that that wasn't fulfilling for me, that I wanted to be part of the storytelling. And sometimes I would have people who really resented that because they were like, we just hired you to be an actor. I wouldn't reveal that I actually need to have authorship in order to feel fulfilled. So I think that for them, sometimes that might have felt like a rug pull because you're trying to assert yourself into something that we didn't hire you to. See https www.forbes.com video 6312607947112 Blake, Lively, taking the entrepreneurial stage, 2022, Forbes Power Women's Summit, emphasis added. 15 Case 1. 24 CV 10049. LGL document 162 filed 040325 page 25 of 45 the editing process. During the strike, Baldoni began editing the footage shot in the first phase of production. FAC 66. Lively's involvement took on a more insistent and manipulative tone. FAC 68. Lively began demanding access to the dailies, raw footage, as well as early cuts of scenes. ID. For those in the film industry, such a request by an actor is highly inappropriate and unorthodox because it intrudes on the domain of the director. ID. Baldoni and the film's editors feared that Lively's incremental demands would turn into a complete takeover. FAC 69. After the SAG-AFTRA strike ended on November 9th, 2023, Baldoni, Wayfarer, and Sony were eager to resume production. That same day, however, Lively's lawyers blindsided them with a 17-point list of non-negotiable conditions that must be met before Lively would return to work. FAC 75. The list was drafted for the apparent purpose of insinuating or outright claiming that Baldoni, Heath, and others had engaged in sexually inappropriate conduct during filming. ID. However, and nothing could be further from the truth. ID. When Wayfarer and Sony attempted to revise the document to make it factually accurate, Lively's counsel responded that the list was not open for negotiation. FAC 76. Wayfarer was forced to sign the document as is, despite the falsity of its insinuations, lest they lose millions of dollars, cost hundreds of people their jobs after they had been out of work for months, and destroy their relationship with Sony. FAC 77. Notwithstanding the insinuations, however, the demands themselves were agreeable. Indeed, some were already in place. ID. Regardless, as alleged in the FAC, Lively used the 17-point list to extort the Wayfarer parties and Sony into giving her editing rights, FAC 133 to 39, allowing her to create her own cut of the film, FAC 140 to 47, removing Baldoni from all marketing and promotional materials, FAC 147 to 49, 158, 161, 163. Sponsoring Lively for a PGA mark, which the Wayfarer parties characterized as extortion in real time, FAC 152 to 57. FACXA at 92 to 93, and excluding Baldoni from the premiere, FAC 166 to 71, among other ruthless demands. To the extent Wayfarer assented to these demands, they did so staring down the barrel 16 case 1:24, CV 10049, LJL document 162 filed 040325 page 26 of 45 of a gun. In the FAC, the Wayfarer parties dismantle, point by point, the insinuations in the 17-point list. See FAC 79 to 123 as outlined in the Wayfarer parties' pleading, over a collective 391 pages, including Exhibit A, lively fabricated, materially mischaracterized, or grossly exaggerated all of the allegations she made in her CRD complaint and federal lawsuit. Lively falsely claimed there was no intimacy coordinator when Lively was aware that one was engaged 6 weeks before filming began, although Lively refused to meet with her in pre-production, forcing Baldoni to personally relay the coordinator's suggestions about the mechanics of intimate scenes. Facts 79 to 81, 85 to 88, FACXA at 9 to 10. Lively falsely claimed that certain of the Wayfarer parties insisted on being around her when she was undressed or breastfeeding, when in fact, Lively openly breastfed on set and no one ever entered her guarded trailer without advance permission. The FAC includes a text message from Lively to Baldoni, from after the event she later recast as sexual harassment, inviting him to her trailer while pumping breast milk. Fact 104-05, FACXA at 25. Lively falsely claimed that she was forced to be nearly naked during the filming of a birthing scene when, in fact, she was wearing black briefs, a hospital gown, and a pregnancy suit, and only her legs showed. Fact 83 to 84, 119 to 121, FACXA at 27 to 28. Lively falsely claimed that Wayfarer hired a random friend of Baldoni's to play the gynecologist when, in fact, the actor is a Shakespearean-trained professional with an MFA in acting from UCLA. Fact 119, FACXA at 27 to 28. Lively falsely claimed she was shown porn by Jamie Heath when, in fact, in relation to the filming of a birthing scene, Lively was shown a single, non-pornographic clip from a video of Heath's own son's home birth. Fact 101, FACXA at 29 to 30. Lively falsely claimed that Baldoni harassed her during the filming of a purportedly 17 case 124 CV 10049, LJL document 162 filed 040325 page 27 of 45 soundless slow dancing scene. An allegation definitively disproven by raw footage with sound that Lively apparently did not realize existed. Fact 89 to 90, FACXA at 30 to 31. Lively falsely claimed that Baldoni fat-shamed her when, in fact, he privately inquired with her personal trainer about her weight to prepare for a lifting scene due to his long history of back problems. Lively also falsely claimed that there was no such scene, but the relevant portion of the script is excerpted in the FAC. Fact 46 to 50, FACXA at 6 to 7. Lively falsely claimed that Baldoni admitted to committing sexual assault when, in fact, he disclosed that he had been the victim of sexual assault. FACXA at 155 to 56. The foregoing are representative examples and do not come close to capturing the full scope of Lively's fabrications. Suffice it to say, the FAC alleges in the strongest possible terms that the accusations made by Lively concerning sexual harassment and retaliation are false, and that Lively knows and always knew they were false. For the purposes of a Rule 12b(6) motion, it is enough that the Wayfarer parties allege, in factually grounded and non-conclusory terms, that Lively acted with malice and made her accusations without a reasonable basis in fact. The sharp factual disputes between the Wayfarer parties and Lively preclude a ruling on purely legal grounds. B. Section 47.1 does not apply to defamatory statements made by the Sloan parties or Reynolds on Lively's behalf. Furthermore, Section 47.1, by its plain language, does not apply to the defamatory statements made on her behalf by her co-conspirators and agents, the Sloan parties, and Reynolds. For the purposes of Section 47.1, communication is defined as factual information related to an incident of sexual assault, harassment, or discrimination experienced by the individual making the communication. Cal Civ. Code 47.1d, emphasis added. Thus, the Sloan parties and Reynolds statements fall into an entirely different category than Lively's own statements. Although not entitled to protection for the reasons discussed above, Lively's statements bear markers of baseline eligibility to the extent they relate to Lively's own experiences. 18 Case 1:24, CV 10049, LJL Document 162 Filed 040325 page 28 of 45 in contrast. The statements of the Sloan parties and Reynolds, which also purport to relate to the experiences of Lively, were not made, as the statute requires, by the individual alleged to have experienced an incident of sexual assault, harassment, or discrimination. ID. Section 47.1 does not extend to, and in fact is expressly drafted to exclude, third-party communications. Given their lack of protection under Section 47.1, it is not necessary to separately analyze malice or reasonableness, although the Sloan parties and Reynolds statements fail on both counts. 6. The fair report privilege does not apply. The fair report privilege renders privileged a fair and true report in, or a communication to, a public journal of a judicial proceeding, or e, of a verified charge or complaint made by any person to a public official, upon which complaint a warrant has been issued. Cal Civ. Code 47d1. As Lively acknowledges, the fair report privilege is typically invoked by news media defendants in connection with publications concerning judicial proceedings. Health Smart Pack, Inc. vs. Cabatech, 7 Calories App. 5th 416, 431, 2016, as modified, Jan. 10, 2017. However, the privilege also protects those who communicate information to the media. ID. But the fair report privilege, by definition, only applies to communications relating to an official proceeding, so Lively is forced to recharacterize the allegations against her beyond recognition. In Lively's telling, the defamation claim is based on her leaking the already filed CRD complaint to the NYT, which subsequently published a fair and true report on its contents. This account diverges sharply from what is actually alleged in the FAC. As alleged, Lively, Reynolds, and the Sloan party started working with the NYT months before the CRD complaint was filed. Fact 4, 36, 86, 256-69, FACXA at 157-68. Indeed, the NYT apparently started working on its story, fed by Lively and her co-conspirators, as early as October 2024. FAC 268. Lively did not file her CRD complaint until December 20th, 2024. Fact 263. FACXA at 157. The crux of the FAC is that Lively worked hand-in-glove with the NYT throughout the Fall 19 Case 1. 24 CV 10049, LGL Document 162 Filed 040325 page 29 of 45 of 2024. Feeding its reporters defamatory statements and coordinating closely with them to ensure the end result would amount to a kill shot to the Wayfarer party's reputations and careers. This had nothing whatsoever to do with any then ongoing judicial proceeding. When the NYT finally dropped its bombshell, multi-thousand-word feature nearly simultaneously with Lively's request for a right to sue notice and its legally pointless sham attachment plainly aimed at the public. It was after months of secret collaboration during which Lively and her co-conspirators made false and defamatory statements about the Wayfarer parties. Fact 4, 17, 96, 263-69 at the time they were made. These statements bore no relation to any judicial proceedings. and they are therefore ineligible for the protections of a privilege predicated on the pendency of such proceedings. FAC 269. The fair report privilege does not protect Lively, nor does Lively address the defamatory statements made to those other than the NYT. These include those made by her agents and co-conspirators, Reynolds, and the Sloan parties in the summer of 2024. Fact 8 162, 189 to 90, 193, 282, 325, FACXA at 99 to 100. As alleged, in or around August 2024, the Sloan parties made defamatory statements to the Daily Mail and other outlets to the effect that Baldoni is a sexual predator who sexually assaulted Lively. Fact 8 193, 282. Reynolds, on at least 2 occasions in or around July 2024, made statements to executives at WME to the effect that Baldoni is a sexual predator and that WME was in business with a sexual predator. Fact 8 162. FACXA at 99 to 100. These statements are even more attenuated from any judicial proceeding than those made to the NYT, and they were made at Lively's direction as part of a conspiracy to destroy the reputations and careers of the Wayfarer parties. 7. The FAC alleges that Lively acted with actual malice as a matter of constitutional law. If the person defamed is a public figure, he must prove by clear and convincing evidence that the statement at issue was made with actual malice, i.e., 20 Case 1. 24 CV 10049, LJL Document 162 Filed 040325, page 30 of 45, with knowledge that it was false or with reckless disregard of whether it was false or not. Reader's Digest Association v. Superior. Court, 37 Calories 3D 244, 256, 1984. Citing New York Times Co. v. Sullivan, 376 U.S. 254, 285 to 86, 1964. The Supreme Court has explained that while the concept of reckless disregard cannot be fully encompassed in one infallible definition, the defendant must have made the false publication with a high degree of awareness of probable falsity, or must have entertained serious doubts as to the truth of his publication. Hart-Hanks Communications, Inc. v. Connaughton, 491 U.S. 657, 667, 1989. There is compelling evidence that Lively fabricated her accusations, was aware they were probably false, or at least entertained serious doubts as to their truth. See Burrell v. Nair, 217 Calories App. 4357, 390, 2013.